This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And we are now joined by Todd Lutsky from Cushing & Dolan. We got the phone lines open at 888-205-2263. That is the number to call to ask Todd your questions live on air today. Again, 888-205-2263 is the number. Todd will answer your questions live on air about your estate plan, your lack of estate plan, a friend's estate plan, family member's estate plan, you name it. Again, 888-205-2263. We usually get through a couple of calls, so get calling early and often if you want to make sure we get to you. And that number one more time is 888-205-2263. Mr. Lutsky, how are you?
I am doing great. You?
Doing pretty well. I was thinking the other night about the state of Oklahoma.
Oklahoma? Why
Oklahoma? I was thinking about its abbreviation and whether I like it or not, and I just decided it's okay.
That's good. It is okay.
Yeah,
it's
fine.
just okay.
It's fine.
Yeah.
Let's talk a little bit about irrevocable trusts, specifically irrevocable trusts that protect assets against long-term care costs.
Okay.
When you look at establishing one of those trusts, who can be the trustee of that trust? Can it be yourself? Does it have to be someone else? How is that structured?
So that has evolved over time, right? So irrevocable trusts, can you serve as trustee of your own irrevocable trust? Well, the answer is you can, and we've won the battles when it comes to that challenge as to whether you can or can't be. But it's something over time that I've just decided we don't do. I don't really see any benefit in serving as trustee when you can just put a child on as trustee, avoid any of these potential issues, and most importantly, keep the power to remove and replace the trustee by the donor anytime. If you have that power, then really you're the one directing the show anyway. And you have avoided any potential issues.
What are the responsibilities of that trustee then? What do they have to do on a day-in, day-out basis? Is it a lot of work for them? Is it a small amount? Like, what do they actually have to do?
Yeah, and a lot of times parents will say, well, geez, I don't want to burden my child with all these headaches. Well, it really depends on what you're putting in the trust. I mean, if you stop and think about it for a minute and the only thing you're putting in the trust is your home, or let's say your home and your vacation home, none of which are being rented and therefore generating zero income, I'm going to tell you that there is absolutely nothing for the trustee to do. Nothing. No tax returns, no headaches, no nothing. It's only if you were to get into having investment type money portfolios and things inside the trust that maybe once a year you got to file an income tax return and sign your name. But even then, there's not a lot to do day to day because the donor, the moms and dads of the world, are really doing almost everything.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. Still room on the phone lines at 888-205-2263. That's the number to call to ask Todd your estate planning questions. Again, we do still have a little bit of room on those phone lines at 888-205-2263. We're going to take a quick break here, but when we come back, it is going to be right to your phone calls. Again, that number is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
Alrighty, let's get right to your questions for Todd Lutsky. First up, we got John in Arlington. John, what's your question for Todd?
Yes, thank you for taking my call. The reason why I'm calling is my wife and I are in the beginning stages of getting estate planning documents drafted, and we've talked to some friends about what they have done, and we've seen instances where one spouse had a trust drafted, the other spouse had a trust drafted, and they were both co-trustees of both trusts. Mm-hmm. But then there were some other situations where the attorney just drafted one trust for the household, where both spouses were trustees. And I was just curious what would be the benefits or disadvantages of one versus the other.
So, I guess, how old are you guys?
50s, mid-50s.
And so the other issue is the size of the estate might matter. Are okay. You under, let's call it $14 million?
Yes.
Okay.
Yes.
Well, I mean, it just makes a difference. Yeah. So are you over $4 million?
Combined, yes.
Okay. So you're in that area where estate planning makes a lot of sense for Massachusetts because, right, there's a $2 million exemption, and we want to make sure we shelter as much as we possibly can on the first death. So people that are doing, and I assume you're looking into a revocable trust, correct?
Correct. Yes.
Yeah. And so and that makes a lot of sense, but I can tell you for people that are under that, and let's just call it 14 million. I don't really have a hard and fast rule for this. I just try to think about the estate tax exemptions that are in effect federally when defining what I call a moderate estate. So for smaller estates that way, under 14 million, give or take, one trust is absolutely the best way to go. There is no reason to be dividing assets between two trusts. It's more complicated, requires more effort, and shelters less assets for estate tax purposes, right? Example, let's say we were worth, $4 million, but, $2 million of it is in an IRA. Well, I can't put the IRA in the trust, but I can put everything else in the trust. Okay, so I take my $2 million of non-IRA assets and I divide them between a husband trust and a wife trust. And then husband dies. Well, how much is in the trust? $1 million. Okay, well then I'm able to shelter $1 million from estate taxes. Unfortunately, in Massachusetts, we have a $2 million exemption. Well, I wasted $1 million of my exemption when I died because I only had $1 million in my trust. However, if you draft a joint trust correctly, on the first death with use of a general power of appointment, you will be able to include the full $2 million in the estate of the first to die. And therefore, now I'm sheltering $2 million on the first death, wasting none of my exemption. So when the surviving spouse dies, they might only be worth the $2 million, which would be the IRA asset, and thereby eliminating, not just reducing, at least the Massachusetts estate tax. Remember, federally, it's way higher than that anyway. Problem you run into is you might not find lawyers that understand how to do the joint trust. So joint trust is my answer. That's the way to go. Folks, that's just one kind of trust that's out there. There are many, and the one we're talking about in the guide today, not that one is right or wrong, but the one we're talking about in the guide today is the irrevocable Medicaid trust. It is, quite frankly, one of my favorite because it just lists all answers. It's a question-answer format. Over the last 30 years, I've put together the most frequently asked questions I get on these trusts. All the do's, all the don'ts. What can I put in? How do the taxes work? How much control do I have? Can I collect rent? I mean, one after another, folks. So if you've never done an irrevocable trust, but you're thinking it might be for you, or if you've ever been afraid of them, call and get the guide and learn how they really work. 866-848-5699. or legalexchangeshow.com. One more time, 866-848-5699 or legalexchangeshow.com.
Todd, I got one more for you here. Let's go to Kathy in Tingsboro. Kathy, you are on with Todd Lutsky.
Yes, good morning, and thank you, Todd, for taking my call.
Mm-hmm.
I've been listening to your show for a while. I do have questions.
Okay.
My husband, they have family trust with property that hasn't been sold yet.
This is you and your husband?
It's his family.
Oh, his family.
My husband's family.
Okay.
But then my question is, I inherited money from my dad, and I have my own retirement money, and beneficiaries have been set up for all of this.
Mm-hmm.
Do you advise a trust?
Well, I think there's a lot more I need to know. So you and your husband, you're married, correct?
Correct.
And you have kids?
Yeah.
And is this a first marriage or a second marriage?
First marriage.
Okay. So I would suspect that the fact that you inherited money is probably not an issue. I would tell you to add up all of your assets, including the inherited assets, add up all of the assets that your husband have, put them together and give me a number. Is it bigger than $4 million or less than $4 million? Real estate money?
Right, less than $4 million.
Less than 2?
Maybe 2 or 3.
Good. So perfect. So we're in that $3 million range. It would seem to me, and one last question, how old are you?
66.
So it would seem to me that in that range and that age, I would be suggesting the following to you and your spouse. I would say, do you guys want to avoid probate? Probably. Do you want to not pay Massachusetts death tax since you're north of $2 million but south of $4 million? Probably yes. Do you want to provide a bloodline plan to your family? And again, that's how do these assets get where I want them to go and when and why and all of that. And then lastly, I would ask you if you want to protect assets from the nursing home. Would that be on your list as well?
It would, yeah.
So all 4 of those things is going to require a lot more than just naming designated beneficiaries on IRAs. I would suggest exactly the kind of trust I'm giving away this week or this month in the guide. The irrevocable Medicaid trust. And in your case, there probably needs to be 2. One for wife, one for husband. This is very different than the prior caller who's doing a revocable trust, which is why I indicated one trust was better for them, but revocable trusts provide no protection from the nursing home. They do a lot of other things, but not that. So for you, I would recommend the 2 irrevocable trusts. Sit with the lawyer, learn how they work, get the guide, learn how they work, and then if it's right for you, get it implemented. Hope that helps a little.
Todd, when we're talking about, I want to go back to talking a little bit about irrevocable trusts here and, specifically how they function. We talked about what a trustee has to do. What does the grantor of that trust have to do? Is there any responsibility for them related to the trust? Specifically, how does it work on their taxes and stuff like that? Like, is there anything that goes on either annually or monthly that they need to do?
So what I'll do is I'll take Kathy's call and pretend that they are the donors, just to make them feel like the husband and wife. And the good news is that there is going to be very little to do, and you're going to have a lot of control. So, Kathy, if you're listening still, and this is a concern of yours, how do these trusts work? You would probably put your house in and, maybe some of your investment non-IRA money in there. And then, at that point, we would be able to say, you could live in your house. You could collect the income. Maybe there's a tax return that has to be filed once a year. You're going to pay your normal bills like you always pay. So I don't really see that being a lot of effort, right? And I think what I'd like to have clients take away from this is, what's the worst case scenario? What is it that I'm really doing day to day? It's really going to be very little. It's not going to disrupt your life much at all. So I think people need to take that sort of away from this.
What if you want to sell a property that's in that irrevocable trust? What do you do versus what does the trustee do in that situation?
So if you want to sell, and you're right, that would be, again, something that's not infrequent. I mean, it is infrequent, rather.
Yeah.
So you're not running around doing this. This is not a problem.
No, you're not selling a house every day.
Every day. So when you are doing it, you simply direct. Remember, you direct. So the husband, wife, the donors of the world, direct the trustee, put the house on the market. Trustee doesn't listen, you remove and replace the trustee. So you're really in charge of the sale. And you get it sold, just same paperwork, no additional paperwork. And as long as it's a grantor trust for income tax purposes, it is income tax neutral in terms of the taxation. They will pay the exact same tax they would have paid had they not sold the trust, had they not sold the house via a trust. So, folks, couple of questions, but hopefully the answers show you the flexibility you have with these trusts.
Todd, thanks for joining us.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.